Welcome to episode 20 of the Cashflow Connections podcast. Today, I am going to ask every question that you wanted to ask your attorney but didn't. So we're going to get into a lot of different topics today. We're going to talk about what a security is. Obviously, that's a basic question, but our guest has a very detail-oriented and accurate answer for this. We're going to get into some of the different ways in which you can raise money via securities or syndicated structures. So we're going to talk about Regulation D, Reg A+, Reg CF, which is not very well known, and the difference between 506B and 506C. Now, if you're not familiar with all of these, you're about to be quite knowledgeable because we go into a lot of the details of each one. Also, our guest is going to provide us with a few suggestions in terms of what not to say when raising money, what provisions you should be paying attention to, things like that. But generally speaking, I'm going to do what most investors want to do when they get a really knowledgeable attorney on the phone with them, which is say, well, can you do this? Well, can you do this? Well, can you do this? And if you guys have done that before, the answer sounds like this. Nope, 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 nope. But it does make for an interesting conversation because I want to kind of put out there some of the things you should be considering when raising capital or investing in opportunities. And you can also tell a lot by the way that attorneys answer questions in terms of there's usually gray areas in a lot of these questions, but it's important to understand where the gray areas are. And it's important to understand where you should totally not be doing certain things. And so that's why this conversation is so important. And our guest is very knowledgeable, but also very willing to go down that rabbit hole. So it makes for a great conversation. Now, of course, remember, we are not providing legal advice. Even though we have an attorney on the call, you obviously want to contact your personal attorney that understands your entire situation, can give you a big picture understanding of what is and what is not appropriate. But regardless of that, it's always good to have multiple attorneys' opinions, and we definitely don't want to give the impression that we're providing legal advice on the show. Also, before we get to the episode, just a quick update. We have a new referral program which we're going to be unveiling. So if you are interested, if you have friends, family members that are accredited investors that are interested in real estate opportunities, don't hesitate to send me an email at hunterthompson@cashflowconnections.com. I will send you your personalized referral link where if people sign up using your link, you will get a $200 Amazon gift card for each accredited investor that completes their introductory call. Now, there's a maximum of 5 accredited investor referrals, but that would be 1,000 smackers in Amazon dollars, which is just about as good as anything. So if you're interested in referring some accredited investors to Cashflow Connections, make sure to send me an email at hunterthompson@cashflowconnections.com, and I will forward you your personalized referral link. But this is really important. We're only implementing this program until November 15th. So make sure and send me an email right now at hunterthompson@cashflowconnections.com. I'll send you your link so you can get out these referrals. Sound good? All right, let's get straight to the episode. How's it going, everyone? Our guest for today is Jillian Sidoti, who is one of the country's leading experts on crowdfunding. Her firm, crowdfundinglawyers.net, focuses on securities transactions with an emphasis on servicing small businesses and entrepreneurs, providing them with PPMs, Reg A filings, and small public offerings. Prior to her career, Jillian owned and operated a record label, enabling her to travel the world with artists. She also worked in commercial development and held various positions in the financial field in manufacturing, real estate, and financial services. Jillian has taught finance and accounting for the BS and MBA programs at the University of Redlands, and she is also the author of The Crowdfunding Myth, which debunks the multiple myths surrounding crowdfunding and teaches the reader how to effectively crowdfund their securities. So with that background, I'm not exactly sure what your hourly rate is, but I am confident our listeners are going to get quite a bargain on this conversation. So thank you so much, Jillian, for coming on.
Thank you for having me. I really appreciate it.
Absolutely. So I've listened to several of your talks, and a lot of them start out with the same question. And there's a reason for this, which is that your answer is very accurate and it's very detail oriented. So before we jump into the details of the conversation, let's talk from a big picture. What is a security and how would you define that term?
So a security is really anytime there's an exchange of money in exchange for a profit or a return on investment, which is actually probably a better way of saying it, because when we hear the word profit, we sometimes think, oh, it has to be an equity interest, and that's simply not true. So the test I always like to do is the test that actually is tried and true, is the Supreme Court test that came down back in 1946, and it's this. Security is anything where there is one, an investment of money, two, the investor or the person who's providing the money expects some kind of return on investment, three, the person who's investing isn't really doing any of the work. They're just passive, if you will. And four, there is more than one investor. So if you have if you have all of those elements, there's an investment of money, the investor expects some profits, there's somebody else is doing all the work, and there's more than one investor, then you're selling a security. And that can take many different forms. It can be a note, it can be an interest in an LLC, it can be interest in a partnership, it can be a share, it can be a stock, a bond, a debenture, any number of things.
Okay, perfect. And from a big picture perspective also, what are some of your thoughts on when syndicators or operators complete single equity raises on a per property basis with one investor, or create, a syndication where they're taking on multiple investors and entering the world of securities?
So in both situations, they have to be careful, right? Because the thing is I did say in that last statement about what a security is, there's more than one investor. But there have been many a times where the SEC and the state securities boards have construed more than one investor as more than one investor in you, the issuer, or the entrepreneur as the common enterprise. So a very typical thing that will happen is that an entrepreneur will go out and try to raise money from one investor for one property, and then they'll do it again. And the SEC and the securities commissioners, if they feel that there is a problem, they will link those two together and call it a security so that they can, essentially nail you. So you always want to be cautious with that. The likelihood of you getting nailed in that situation is a lot lower, of course, because it's a matter of time and resources for the securities commissioners to take on smaller entrepreneurs. But smaller entrepreneurs are also low-hanging fruit. They're the ones who have the least amount of money to defend themselves. And so keep that in mind. As for syndications are concerned, the methodology with doing a syndication where you have multiple investors investing in the same property is, providing the proper disclosure, which usually comes in the form of a private placement memorandum.
Got it. And that's definitely something we'll want to touch on today. There are several ways to avoid actually technically registering with the SEC when you have a security. But before we jump into that, what does it really mean to register a security with the SEC, or to, quote, be registered with the SEC?
So we're talking about two different things. There's a registration with the SEC, and then there's an exemption from the registration, exemption from registration with the SEC. And the thing is it always gets very confused, and rightfully so. As a matter of fact, I was reading a document the other day where I used the word registration, and it was improperly used. So even I make the mistake. But I want to say that there is a huge distinction between registration and exemption from registration. And oftentimes people believe that an exemption from registration means you don't have to do anything at all. But that's simply not true. You actually have to actively do something in order for the exemption to work. And those things that you normally have to do, and the exemption we're usually talking about is the exemptions provided under Regulation D, or sometimes people hear it as Rule 506. So exemptions provided under Regulation D, Rule 506, allow you to raise money from usually just accredited investors, sometimes accredited and sophisticated investors, so long as you provide them with the proper disclosure, number one, and number two, you file what's called a Form D with the Securities Exchange Commission and the states in which you have investors. And filing that Form D is is basically putting on notice the Securities Exchange Commission and the state securities commissioners that, hey, I'm using this exemption. I'm following all the rules under the exemption. I'm doing proper general solicitation, or I'm not doing general solicitation at all. I'm using accredited investors or a mix of accredited and sophisticated investors. Those are the steps you basically have to follow. I've provided them all with the proper disclosure on what we're doing. The opposite, or not so much the opposite of that, but the other form is registration. That's like going public, almost like doing a Regulation A plus offering where you're qualifying the securities, or you're doing a permit offering here in the state of California where you're going to the state and saying, here is what I'm going to disclose to my investors. Now give me permission to sell it. And you're actually asking for permission to sell it. So these are like things like when you see an IPO for the first time, that's a registration.
Right. That actually, that language is much more clear. And so I appreciate you making that clarification there. So you mentioned Reg D and Reg A, and kind of, we talked just briefly about Reg D, but talk us a little bit about Reg A, and because that is something most investors aren't that familiar with.
Right. So Reg D is, again, that exemption, and Regulation A is somewhat new. Well, let me back up a little bit. Reg A has existed for a very long time. However, when the Jobs Act passed in 2012, it augmented Regulation A incredibly, and much to my joy, I suppose. I'm very happy about the changes to Regulation A, because now and I won't bore you with what Reg A used to be and how difficult it was, but now under Reg A, issuers, entrepreneurs can raise up to $50 million from any investor, whether they're accredited, unaccredited, sophisticated, and they can use general solicitation. So that means you can now do Facebook ads. You can go on LinkedIn. You can go in front of a RIA group and say, hey, I'm looking to raise capital. Who wants to invest with me? You can do all of those things. The big but is you have to get permission from the Securities Exchange Commission. So you do have to take that qualification statement, that Form 1A, basically your offering circular, and say to the Securities Exchange Commission, please read this and tell me that I can go out and raise money. So it's almost like when you're going to get a building permit. It's very similar. You're getting a building permit in order to be able to construct on your property. In our case, we're going to get a securities permit, if you will, to get permission to sell our securities. And it has been awesome for my clients. It's given them so much freedom in terms of how they raise money. It's just that initial hurdle, getting over that initial hurdle of getting approved by the Securities Exchange Commission can be a little daunting, because we're talking about the difference between, putting together a PPM in 30 days or less versus a 4 to 6 month process with the Securities Exchange Commission.
Got it. Okay, perfect. So just to clarify, Reg D would be an exemption for registration. Reg A, you are registering with the SEC, and that's the major hurdle there that you're kind of talking about.
Correct.
And then there's also something called Reg CF, or Regulation CF. Talk us briefly about that and what the distinction is between that and Reg A.
So I want to say that Reg CF is really most appropriate for those small startups that are going to use that Reg CF to kind of catapult, or I'm thinking of a rebounder right now, like a trampoline where you jump and then you jump up. Mm-hmm. I see these Reg CFs as little trampolines where you're jumping on it as a means to jump up onto something else, and jumping up onto something else normally is a Regulation A offering. And this is why, because under Reg CF, you're only allowed to raise up to $1 million. So you're only allowed to raise up to $1 million. Not really great for real estate, of course, because we always want to buy more properties and get into bigger and badder properties that usually require more than $1 million. But that's not really the big holdback, because $1 million can be a nice chunk of change and can really do a lot of great things. The big holdback is that under Reg CF, you have quite a few limitations. Number one, you can only advertise your opportunity on a registered crowdfunding platform or portal, a registered crowdfunding portal, and those portals are registered with FINRA and have to follow very specific rules. So first you have to find a portal that will take you, number one. So you have to find the portal that will take you, and then you have to pay that portal. So the portal's not going to just list you for free. So then you have to pay them. Then you can only raise $1 million. And then, and this is the big thing that the reason why I don't love Reg CF for real estate specifically is that you can only take up to $10,000 from any individual investor. That's it. That's the max you can take from any individual investor is $10,000. That's not a whole lot of money. And most of the time, what people are investing on these platforms or portals is like $500, $1,000, maybe $5,000. So you're taking tiny bits of capital from lots and lots of investors, and you're kind of jumping through a couple of different hoops in order to get on that platform, on that portal, start marketing. And there is no guarantee you're going to raise money on any of these portals. You have to still bring your own investors to the table when you get listed on these portals, as it turns out.
Got it. Okay. That makes total sense. And just to kind of circle back with the Reg A, are your clients using Reg A significantly for real estate purposes then?
Yeah, I would say the overwhelming majority of offerings that I'm doing right now under Regulation A are for real estate. Lots of mortgage funds, a couple of like multifamily type funds, mixed asset class funds, things like that. A couple of single family flipping funds, just a variety of real estate stuff for sure.
Okay, perfect. That helps put in perspective as well. So also in the Reg D sector, there is, and correct me if I'm wrong, because I always want to make sure my language is correct, but there is within that the 506B and 506C. 506B is something that's been around for quite some time, and 506C was relatively recently introduced with the Jobs Act. So talk briefly about the difference between the 506B and the 506C and the advantages and disadvantages of those.
So 506B is frequently referred to as the old rule, and it's still a good rule. Even though it's the old rule, it's still a good rule. And because it was the original Rule 506, and what it allowed you to do and still allows you to do is raise as much money as you want from both a mix of accredited and sophisticated investors. And if you don't mind, I'm going to define accredited real quick. An accredited investor is somebody who makes at least $200,000 a year as an individual, $300,000 a year as a married couple, or has a minimum net worth of $1 million exclusive of their primary residence. A sophisticated investor is someone who perhaps doesn't have that income or net worth, but understands the risks associated with investing. And this is a very subjective test. You want to analyze your investor by what kind of classes have they taken, what kind of educational background have they had, what kind of investments have they made before investing with you. So under the old rule 506B as in boy, you can raise as much money as you want, take it from accredited and sophisticated investors, but you cannot use any general solicitation. And what that means is you can't go on the internet and say, hey, who wants to invest? I'm offering 8% preferred return. All of those things you cannot do. So you have to do traditional forms of marketing, which is more educational based marketing, or, positioning your company as opposed to positioning your security offering, things like that. And by the way, even though that sounds like a big downer, I can't do general solicitation, how am I supposed to find investors? 506B is still the most popular way to raise capital.
Yeah, that's okay, perfect. So that makes a lot of sense. And just to clarify, we'll probably go into some of the language there, but again, 506B, if you have a company that utilizes that structure, you can still advertise for your company. And that's what Jillian's kind of speaking to. You can advertise for your company as a whole. You can put out educational content. You just simply can't say, click here to invest in the Holiday Inn. That's going to return you 13% on an annualized basis, because that's a specific security. And that's kind of where you get into the 506C structure. So talk us a little bit about that structure and the difference there.
Yeah, exactly. And then 506C we can do that type of advertising. We can say, click here to invest in multifamily properties today, click here to earn 8% preferred return. You can say all of those things under 506C. But the big but in 506C, however, is that you can't take any of those sophisticated investors. All of your investors must be accredited, and you must verify that they're accredited. So the liability shifts. Under 506B, the investor says, hey, I'm accredited, and you can take them at their face. You can take them at what they're telling you. But under 506C, if they are to say, hey, I'm accredited, you have to verify that they're actually accredited and make sure that they're actually accredited. So that's where the difference lies.
Right. And part of that challenge that goes along with that is a lot of companies use third-party verification. And this is an extra step in the investment process, which can be kind of tedious, even though the businesses are being disrupted, the industry is being disrupted to take advantage of this new regulation. It is challenging, especially when you're dealing with a significant amount of investors. Just something to keep in mind. But I have a feeling that it will become more popular as those services that facilitate that become, better at providing that service. I mean, it's just like any other market that changes because of the regulations. Let's talk just real quick about the language you can use in these two things. You mentioned briefly about, not specifically advertising for deals, but other than that, what are some of the things you want to be careful about saying when you're marketing for your company or for a specific security?
Well, it's actually pretty straightforward. Number one, you just don't want to use the following words: safe, secure, guaranteed, and low risk. And I often get, a lot of resistance on the secure part because people say, but I'm securing it with a property. In some cases that may actually be true, but in most cases I find that it's not, and people are using the terminology incorrectly. But more importantly, it's a word that the SEC and the state securities boards hang on. They're looking for that word. They're looking for you to. That's a screw up to them. And if you're using that word, they know that there's something else there that they can latch on to.
Got it.
So those are the four words I want you to never use: safe, low risk, guaranteed, and secure, because those are they're buzzwords that they're looking for. And in some ways, a lot of ways, it's simply not true. And I'll talk about safe and low risk. Although real estate entrepreneurs who've been doing real estate for a long time can say to you that real estate is less risky than the stock market and more safe than the stock market because it's an asset that you can look at, you can touch, you can feel, you can insure, unlike your stocks in the stock market. However, there's a whole bunch of risks behind those great things. So it is not low risk, it is not safe, and the Securities Exchange Commission and the state securities boards will point to multiple examples as to where it is not low risk or safe, and they could just start with the year 2008 and go from there.
That's a good point. In terms of, there's a couple different progressions in terms of, the size of the legal documents, the amount of fees incurred. Where do you start to think in terms of capital raise size that it makes sense to go from, let's say, an operating agreement with the risk disclosure section to a full PPM with the entire operating agreement plus all disclosures plus all the bios, et cetera? Where does that line kind of stand in your opinion?
And this is a hard and fast rule actually in our firm, and it's $500,000. If you're raising more than $500,000, you should be providing full-blown docs to your investors.
Wow. Okay. Well, that is the straightforwardest answer I've ever received on that question, and I appreciate it.
Well, it's funny because, and I have to always put this disclaimer, that's not written anywhere in the law.
Right.
We just think that's the best practice.
Yep. That makes sense. When looking at a PPM, what are some of the clauses that sponsors or investors should pay special attention to when reviewing those documents?
The first one you want to look at, and you might not care about this so much, is what are your voting rights as a member? Make sure you go in with eyes wide open on what control you have. Personally, I could not care less if I have any control when entering into this type of investment. And the reason why I don't care is because I'm not investing so I can control things. I'm investing so that I can be passive. So that's number one. And you know that because Hunter, I invested with you guys, and you guys, I don't believe have any voting rights in your documents, and we don't allow our issuers to have voting rights either. Or allow their investors to have voting rights. And the reason why is because, and this can swing both ways. One, you don't have any voting rights, number one. But number two, if you're investing in a larger syndication or any syndication for that matter, and the other members have voting rights and you don't know who those members are, you certainly don't want members who you don't know trying to take over control. So it's actually in your favor if you have no voting rights, because that means the other investors who you may or may not know don't have voting rights either. And the person that you're investing with that you trust is the one who's ultimately in control. And that's really kind of what you want, number one, as both an investor and as an issuer. Number two, you want to take a look at the distributions and make sure the distributions are flowing in the way that they were marketed to you. So for example, they say 8% preferred return. Well, is that really true? Are you getting 8% before the management's getting paid? Or they'll say something like 14% IRR. Well, is that really possible with the way the distributions happen? The third thing you want to look at is the fees paid to the manager. And see if what they're saying about fees is actually true. How many fees are they getting? What's that look like? And the fourth thing I always look at is the use of proceeds. How exactly does the management contend to spend the money? It's funny because I just read a Regulation A the other day that was just filed not too long ago, like a week ago, and I flipped straight to the use of proceeds, and it literally said, we're going to spend your money however we feel like it. And I am not going to invest. So
wow.
Yeah.
Wow, that's interesting. And in fact, I really like a lot of those points you just brought up. Number one, I agree completely about the voting rights. This is something that comes up frequently. At the end of the day, if you're making a bet on a person, you want to know that that's the person that actually is in decision-making control, to your point about voting rights. So if you do all this due diligence on that team or that syndication or that syndicator, and then at the end of the day, there is a large investor, which could have a significant portion of majority ownership, they could swing the vote one way or the other, and you don't have the capacity to conduct due diligence on them. So it's just something to kind of consider there. And then additionally, actually, what was the last point you made? Because I want to make a point about that one as well.
Was it the use of proceeds?
Yes, exactly. So you can see that they need to specify where the money is going on a line-by-line item, meaning that where's the purchase price? Is there a consulting fee? Is there a due diligence fee? Is there some kind of other, is there a technology fee? Because this stuff can add up. So you want to make sure to take a look at that, because if they have discrepancy, that is not, the incentives are not in line, to say the least. So that's kind of, the easiest way to look at that. One of the things that sponsors kind of struggle with is they want to be compensating or compensate people for introducing them to other investors. Is there ways that this can be done legally without violating certain broker-dealer laws, or how do you suggest your clients navigate that?
I get this question all the time, and I always do a little wince, if you will, because it's a very touchy subject. And what I want to tell everybody out there who's listening to this is that think about it as just like selling a house. You can't pay a commission to somebody who's not a licensed agent or broker. It's the same concept. You cannot pay a commission to somebody who's not a licensed agent or broker of securities. So how do you compensate, your CPA friend who introduced you to a bunch of his clients who invested in your deal? You can pay him a flat fee of, like a finder's fee, a referral fee, so long as it's not tied to the amount of investment and so long as it's a mere introduction. There is no selling involved. So in other words, your CPA friend cannot provide the private placement memorandum and the subscription agreement and so on and so forth, but rather can merely say, hey, Joe, I know Hunter who has this great opportunity. You may want to talk to him, and just make that mere introduction. At which point, if Joe invests, Hunter can pay, a flat $500 or $1,000, regardless of how much Joe invested to to his CPA friend.
Okay, perfect. And if that one made you wince, then the next one is going to even further that. But this is what we're trying to do on the Cashflow Connections podcast, get through the weeds and get to the questions that are really, making the attorneys wince. So I'll accept that answer and raise you. Can you pay an introduction fee repeatedly for that introduction? Not necessarily based on the investment amount, but let's say that the person introduces you and then they significantly invest on a quarterly basis or something like that. What are your thoughts on that?
I got that same question just the other day from a client, and I literally wrote back, do not do that. Like, the closer you, look, I have to give you, as a lawyer, I have to give you that the sky is falling and, apocalypse is now and, all of those things. So take everything I say with a grain of salt. You've got to weigh the risk reward at the end of the day. Because this is not super black and white. I will cop to that. There are some gray elements in here. With that being said, I don't recommend doing that. See, the closer you get to looking like a commission, the more tenuous the situation becomes. I understand the desire to do that, and I know that people are doing that. My personal recommendation is to not do that, but I know it happens.
Cool. And again, definitely appreciate that perspective. And it's something that I've seen a lot too. I think that that's in line with my perspective on that as well. An introduction fee, the guy doesn't have amnesia, right? The syndicator doesn't have amnesia and just has to get introduced multiple times. Now, to put this in perspective, let's talk about why this is so important, right? So what does it really cost to become a broker dealer? Or how expensive is it to leverage someone else's broker dealer license?
Oh, it can be very expensive. So first of all, the first thing is like, I want to say it's harder and harder not to become, but to be and to maintain your broker dealer's license. FINRA is an organization similar to the bar organization, which is not a government organization, but a privately run self-regulatory agency. And they are becoming worse and worse and worse in terms of how they treat their members. And their members being broker dealers. So it's very difficult to maintain your status as a broker dealer. It's getting more difficult to make money as a broker dealer. The risk tolerance has to be incredibly high because the risk of being a broker dealer, FINRA can rear their ugly head at you at any time. So there's a couple of issues at play. And the first issue is can you get a broker dealer to actually sell your deal? And if you're a brand new syndicator, my answer to you straight out is going to be no. Any broker dealer that's worth anything is not going to agree to sell your deal. It's too risky for them. You're brand new. They don't know what your track record is because you don't have a track record. So most broker dealers are not going to be willing to take that risk. And then the second part of that is a broker dealer that's worth anything is going to cost you 10 to 12% of your capital raise. So it's a nice chunk of change that you're going to have to pay in order to have that service of a broker dealer to help you sell your securities.
Wow. Well, that'll kind of put in perspective why this conversation is so important because that is, taxing. And, on the upside, on the front end, I should say, Jay Kerner, who has been a guest on the show and runs a very large retail real estate company, said that he spent about $1 million becoming a broker dealer in that pursuit of that process. So let's talk about the big picture thesis of the crowdfunding myth. What are some of the myths that you debunk in that book?
Oh, my favorite one is that people think crowdfunding is magical. In other words, if I can just get listed on a crowdfunding platform, all my problems will be solved. And that couldn't be less true. The reality is that you still have to do your own marketing. You still have to have a wow factor that makes you stand out on that crowdfunding platform. And you still have to get your own tribe to believe in the product itself. The crowdfunding platform itself is not going to be the magic that you're looking for. You're asking people to trust you based on what they saw on a website. And, that is hard to come by. So you have to do a lot of work and a lot of consistent marketing to convince the investor that you are the expert you purport to be, and that you have the experience and the know-how and the properties that are worth their hard-earned money. So that is the number one myth to me, is that it's magical, and that you can just get listed on a platform and you don't have to follow any rules and you don't have to follow any traditional rules of relationship building. All of that is not true. You still have to follow securities laws. You still have to do your own marketing. You still have to relationship build.
Awesome. And that book is available on Amazon. We can link to that in the show notes page as well. Very detail oriented as well. A couple of questions about, some interesting topics, but I want to get your perspective on. There's been some changes recently in the self-directed IRA space with relations to the fiduciary laws and the requirement, or it's kind of gray, but and it's uncertain as to how these laws will be effectively implemented. But technically speaking, sponsors could be considered fiduciaries of IRAs. Are you seeing a significant change in the marketplace in terms of what you think is appropriate, or how are you directing your clients in terms of accepting self-directed IRA capital?
So I always tell people, so we always write in our documents that this is a real estate firm, and therefore we expect to be exempt under ERISA, because we are a real estate operating company. And hopefully that holds true. I don't know how that's going to be affected. I have, usually what I do is I try to refer out to a tax attorney who knows more about this stuff than I do, to make sure that my clients don't run afoul of any of these things. And what I would say to my clients is that if you are going to be in the habit of taking ERISA money, is to have a contingency plan in place to cash those ERISA violators out as soon as you find that there's an issue, so you don't have any issues yourself. The other thing you can do is always, to try to avoid this fiduciary issue, is to not take more than 25% of your investors as self-directed IRAs or 401ks or whatever it might be. So that is another way to approach that.
Okay. Makes sense there. This is something that has come up kind of recently with the advent and the popularization of the funds, which allow for multiple properties to be included in a specific fund, which really can reduce the amount of overhead. It can reduce the upfront fees in terms of legal costs, and you can have the diversification from an investor's perspective as well. I have run into the issue where the blanket executive summary is extremely high level, meaning that it doesn't go into the details on a per property basis. They're not trying to focus on the properties. But then you have really sophisticated investors. Like, for example, if I'm doing due diligence on a fund, I want to see a significantly larger amount of details than a typical investor. I have struggled to get the amount of detail that I would want because of concerns of sharing some information with certain investors and not sharing that same information with other investors. What are your thoughts on that? Is this something that comes up frequently from your end as well?
If you're sharing certain information with investors and not other investors, I highly recommend that you don't do that. From a perspective, like I'm not speaking to you, Hunter, I'm saying in general.
Sure.
People don't do that. And the reason why I say that is because you never want to get caught in the way of that. That's what you should have told everyone that that obviously that was a material disclosure that you did not make. So you just don't want to get caught in that issue, if you will. So my recommendation always is if you're going to make the disclosure to one person, make it to everyone. Number one. Number two, the rule of disclosure is this a material enough disclosure that it would influence one's decision to invest? And if the answer is yes, when you're analyzing whether to disclose something or not, then you need to disclose it. That it's really that simple. If you're looking for more disclosure in terms of how the fund is going to run and what the rules and regulations are going to be of that particular fund, then I suggest not investing, although I don't necessarily suggest this, but I'm saying if you're looking for more details, my suggestion would be is to go to a Regulation A fund as opposed to a Reg D fund. You might not make as much money, but you'll certainly get more disclosure.
Makes total sense. There's a lot of investors out there that can rightfully be intimidated by some of this conversation, given the discussions about securities and the different laws, and thinking that, why do I need to complicate my life? What are your suggestions to these new investors that are potentially intimidated by this syndication structure, and talk about some of the advantages or why you suggest and why you like the fund syndication structure so much?
Well, so you shouldn't be intimidated. Everybody has to start somewhere, and there's a lot of people out there doing it. Number one. Number two, this is why you hire a good securities attorney, because you're not supposed to know all this information. And I highly suggest that you don't go out and try to gather all of this information. Know enough just to be dangerous, and then rely on a professional to help you. I can't emphasize this enough. Even before I was practicing law full time, and I was still in law school and I was doing syndications myself, we hired a professional. I didn't try to do it myself. So I really want to recommend that you first come to the realization that you're not going to be able to do this by yourself, or not that you're not going to be able to do it by yourself, but you shouldn't. You should hire a professional. And then the other point is that the fund model does really give you some flexibility in terms of what you want to do. I want you to think about it from this perspective. I've had 3 or 4 phone calls this week alone on people who want to start funds for Houston buying funds. They don't know what properties they're going to buy. They don't know what opportunities are there, but they know there's opportunities there. And,
Right.
and that otherwise wouldn't exist if they didn't have that fund model.
Awesome. Well, Jillian, again, thank you so much for your time. And if you want to just leave your contact information so the listeners can get in touch with you directly, that'd be greatly appreciated.
Absolutely. So my office number is 323-799-1342. And you can email me at Jillian@crowdfundinglawyers.net. And so it's Jillian.
Okay, perfect. And we'll link to that as well. And again, link to the crowdfunding myth, which you should definitely take a look at if you're interested in that topic, which I know a lot of you are. Okay.
Oh, Hunter, can I give one quick plug for our event in February? Do you mind?
Please. Absolutely.
We have this awesome crowdfunding event every year in February in Las Vegas. And it's all real estate crowdfunding. I encourage you to go to crowd2018.com. There's an amazing testimonial video on there of the people who attended last year while they were at the event, and what they learned and who they met. We have an amazing keynote speaker that's going to teach you how to raise money. It's not all law. Our firm hosts it, but there's very little discussion of the law. It's more about the function. How do you crowdfund? How do you do it? How do you get on a platform? What platform should I get on? What accounting service should I use? What other services do I need? And then just the functions of how to actually raise money. So I strongly encourage anybody who's interested in this subject to come out, because it's not an expensive event, but it's lavishly done. We throw all of our marketing dollars into it. So just to really kind of get the word out on how crowdfunding can benefit your business.
Awesome. Well, Jillian, thanks again. I know the listeners really are going to enjoy this one. They definitely learned a lot. So thanks again. I learned a lot too. So thank you.
Awesome. Thanks.
For all the listeners out there, thanks again. I told you we were going to push the limits of what was appropriate, and hopefully we did not disappoint. If you want to get in touch with Jillian, feel free to do so at the information she provided. There is crowd2018.com. Also, crowdfundinglawyers.net is the company, and Jillian@crowdfundinglawyers.net, all of which will be provided in the show notes page as usual. Also, don't forget to email me at hunterthompson@cashflowconnections.com to get your personal referral link so you can refer out all your friends and family and help them enjoy this awesome opportunity in the real estate investment space. All right, thanks again.